I really, yeah, not right now. I want him to focus on his mental health and focus on maintaining his sobriety because he's at Haven for Hope.
All right, folks. Here we have the state of Texas versus Anthony Wayne Monty, a possession of a controlled substance case that's about to take a serious turn. Right out of the gate, we see a plea bargain strategy unfolding, with the state stepping back from the original indictment to a lesser charge, possession of less than 1 gram, pushing this into state jail felony territory. Anthony's lawyer and the court are walking him through a deferred adjudication option, which could be a lifeline if he completes all terms successfully. But here's the catch. Deferred adjudication isn't a get-out-of-jail-free card. If violated, the court can still find him guilty and impose up to 2 years in state jail, plus hefty fines. So, already the stakes are high, and the judge's firm but fair tone sets the stage for a tough road ahead. Stick around, because this case highlights the balance between second chances and accountability in the justice system.
I asked her to secure a better connection. Okay.
Court is calling 2025 CR 007015, State versus Anthony Wayne Monty. Can I have parties announced for the record?
For the state of Texas, Your Honor.
Christine McDonald for Mr. Muncie.
And are you Mr. Muncie?
Yes, ma'am. Yes, Your Honor.
Thank you. Oh, thank you. All right, counsel, have you received all discovery?
Yes, Your Honor.
And did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Muncie, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we are not. We are proceeding with the lesser included possession controlled substance penalty being 1 less than 1 gram to make this a state jail.
Any objection?
No, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Your charge is possession of a controlled substance penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Sure.
Counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, sir.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on the lesser included offense. There is to be deferred adjudication, restitution of $60 to the Bexar County Crime Lab, follow the recommendations of the TAP evaluation. Did you understand that to be your plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, sir.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There'll be 100 hours of community service restitution and take all medications as prescribed. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers State's Exhibit 1 and all attachments, Your Honor.
No objection, Your Honor.
All right, state you may excuse.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, just that I spoke with his case manager this morning. He's doing excellent in treatment. His whole day revolves around treatment, Judge. He has group first thing in the morning, group after lunch, and AA meetings after dinner, Judge. He's doing excellent. We're asking you to take that into consideration with the conditions that the state put.
Now, this is where things get interesting. The court moves forward with sentencing under deferred adjudication. Notice the key conditions: 100 hours of community service, $60 restitution to the crime lab, and importantly, mandatory participation in treatment programs and parenting classes. The judge is clearly taking a rehabilitative approach, focusing on Anthony's sobriety and mental health. But this isn't leniency without strings. Regular reporting via Zoom or in person, random drug tests, and close supervision underline that failure to comply means the deferred adjudication can be revoked, which would trigger a jail sentence. Also, Anthony's indigency status is mentioned, showing the court's awareness of his financial struggles and how that might impact probation fees. It raises a vital question for viewers. Should courts prioritize treatment and support over punishment in drug possession cases? What's your take? Rehabilitation or strict
The
incarceration?
state put, I believe it was minimal so that he can focus on his time at ITP and residential treatment, Judge. And one more thing, Judge, my client has been declared indigent by this court, and if there's any consideration we can do on the monthly probation fees, that would help him out immensely as well, Judge.
So how you doing?
Shannon, day by day, doing my.
Oh, that's good. Yeah, they say you have to take it day by day, but I'm so happy that you're working towards staying clean and sober.
Appreciate it.
All right. So what I can tell you with regards to fees to probation, I take everything in consideration when that's presented to me.
Yes.
Okay. All right. The court, do you have children?
Yes, I do.
What are their ages?
8 and 10.
Okay. Court is going to sentence you to 2 years deferred adjudication. There's $60 restitution to Bexar County lab for drug testing, 100 hours of community service restitution. Once he completes parenting classes, the community service hours will be deemed satisfied. There's to be regular reporting by Zoom or in person, regular random UAs, and probation. If he's receiving the UAs through the treatment program at Center for Healthcare Services, that's acceptable to the court. But if not, you'll have to do UAs with probation. There's to be continued treatment with the ITP program through Center for Healthcare Services on the Haven for Hope campus. And you need to sign a release so that probation can make sure that they receive updates on how you're doing.
Okay.
All right. And probation, you all don't do field visits at Haven for Hope. Is that correct? All right. And we'll do a TAP evaluation out of custody just so that we can have that. Probation, is there anything else? I really, yeah, not right now. I want him to focus on his mental health and focus on maintaining his sobriety because he's at Haven for Hope. All right. Is there anything else you need from the court to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with you?
Yes. Yeah.
Did you understand it?
Yes, sir.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
We can go off the record. I congratulate you on, maintaining your sobriety. But in this court, if you feel like you're going to use, first of all, make sure you make use of the tools that are being given to you for that. And then if that's the case, you can always call probation. And you know what will happen? I will have a compliance hearing. This will probably be your attorney. We'll come in here and see what we can do to help you maintain your sobriety. Okay?
Okay.
All right. Good luck to you. Just remain in the courtroom. Probation will go over conditions.
All right.
Thank you, Judge. All right. Thank you.
To wrap up, Anthony Wayne Monty pled no contest to possession under 1 gram and was sentenced to 2 years deferred adjudication, with strict conditions focusing on treatment and community service. The court's ruling illustrates the delicate balance in criminal justice between holding defendants accountable and offering pathways to recovery. Deferred adjudication here serves as both a second chance and a warning. Comply and stay clean, or face jail time. If you found this case as shocking and thought-provoking as we did, make sure to hit that like button. Share your thoughts down below. Would you agree with the court's approach? And don't forget to subscribe for more jaw-dropping courtroom breakdowns that dive deep into the real stories behind the headlines.